All right, so guys, once again, this is behind the bench. We're learning a little bit about the Supreme Court behind the scenes from people that worked there very intimately several years ago, specifically for Justice John Roberts. So let's get to know it a little bit. First, could you guys introduce yourself and briefly, say hi, and tell us a little bit about yourself? Okay, I'm sorry. I'll try to get a little clearer, Sina. My apologies. But introduce yourself real quick if you don't mind, Sina.
Sure. My name is Sina Kian. I was a clerk on the Supreme Court from 2012 to 2013. Before that, I clerked on the DC Circuit, which is the court in DC that hears all federal appeals coming out of DC. I clerked, as mentioned, for Chief Justice Roberts.
All right, and can you say hi and introduce yourself, Michael, if you don't mind, sir?
Yeah, hi, I'm Mike Clemente, and I also clerked for Chief Justice Roberts. I think my term was 2018 to 2019, but I always get the terms confused. And before that, I had clerked in the DC Circuit actually for the same judge that Sina had clerked for. He actually interviewed me, and despite his protests, I was hired. And then before that, I clerked in the Seventh Circuit, which is the Federal Court of Appeals for Wisconsin, Indiana, and Illinois.
Before we get any further, because we want to go to student questions, and I just want to encourage our guests. First of all, thank you so much for joining us. I know both of you are very busy. Second of all, we have a lot of questions for you today. So I hate to ask that we just try to keep our answers nice and succinct so that they can figure out, they can learn as much as possible from you guys today. Before we get to our first question, guys, can you explain a little bit? You have clerked for John Roberts. He is the Chief Justice of the Supreme Court. What is the difference between a Chief Justice and what we call an Associate Justice, which is the other 8? Go ahead, Michael.
Yeah, well, I mean, if we're going to keep it succinct, it's kind of hard because that's a big question. So there's a few ways that a Chief Justice is different than the Associate Justices, and I will be succinct, but I would say that the main ways are that it's constitutionally specified. So the numbers of justices in the Supreme Court has gone up and down over time. But the Constitution specifically contemplates a Chief Justice. And then in addition to that, I think there's 2 other main differences. One is that as a justice, the Chief Justice is always the senior most justice, which means that it means a lot of things, and we can get into that over the discussion, but it means that he has a kind of place of, he's called sometimes a first among equals. And so he has a sort of leadership position on the court amongst the other justices. And then the other way that it's the Supreme Court, the Chief Justice's role is different, is that he's the head of the federal judiciary. And so that actually includes lots of responsibilities that are really distinct and separate from any kind of work you do as a justice.
I would like to open the floor to our students. We have politically active students with questions that they have come and wanted to pick your brains, you, Michael, you, Sina, starting off with our friend Josh here. Sir.
All right. Hello, my name is Josh Buford. I'm a member of Politically Active here at OTC. And my first question I was just wondering is, I'm sure most of us are wondering, is what exactly being a clerk for the Chief Justice entailed, what exactly you did with your jobs and what are it kind of affected.
Sina, do you want to jump in on that?
Yeah, sure. So the justices each have 4 clerks. Retired justices get 1 to help them with the things that they work on. That 1 can be assigned to other justices as well, but generally speaking, 4 clerks. And what you do is you help the justice stay on top of their workflow. And at the Supreme Court, that means the court needs to hear which cases, or they need to decide which cases they want to hear. So you get thousands of petitions every year, but every year they take maybe like 70 cases or 60 cases or something in that order of magnitude. So you get all these petitions and you read them really carefully and really closely, all the material, and you kind of summarize it in a memo that goes to most of the court. So in that function, you're actually kind of helping the entire court. And then you as a clerk will also read memos that other clerks have written to digest them for your justice. So everyone's kind of sharing the workload there. And then for the cases that the court has agreed to accept, to hear, you will read all the briefing and you will kind of make sure your boss understands everyone's positions, all the legal precedents, and you can answer any questions they have. And then once they decide if your boss is writing, in many instances, you will write a first draft, or you'll work with your boss to write a first draft, and you kind of go iteratively back and forth. And then part of your job is to make sure the draft is like perfect. It's sort of considered every position, it's addressed what it needs to address, and then down to like the periods being italicized where they need to be italicized and not italicized where they don't need to be italicized. So all those details, you're sort of there to make sure that there's housekeeping. And then an increasing part of the court's docket is also these emergency applications, and you just sort of, you're there. The most prominent being the death penalty cases. So you'll have death penalties coming out of the states, and people will have like last minute kind of stays. And so you'll get that docket. And folks who are working on that know they're working on it. So they stay late, they make sure they're there in case anything comes in last minute, and then you help them process that.
Hello, my name is Robert Thomas Gumersell. I'm also a cabinet member here at Ozark Technical Community College. And I was just wondering, does Chief Justice John Roberts, whenever he's in the majority opinion, does he usually prefer to write the majority opinion or hand that down to another associate justice? Michael, would you like to take that, sir? Michael?
Yeah, so he's in the majority for most cases, and he doesn't write most cases. Normally, the majority, the authorship of majority opinions is distributed amongst the justices. So in most terms, most justices are in the majority. In most terms, there's a very sizable chunk of decisions that are unanimous. Between a third and a half, or usually less than half, but around a third of the court's decisions can be very close, either unanimous or very close to unanimous. And so one of his prerogatives as the senior most justice is when he's in the majority, he gets to assign who writes the decision, and he can keep it for himself or assign it to someone else. But he doesn't write them all himself because it's so many decisions. So he's oftentimes assigning them to other justices.
It's a very politically astute way of putting it. I mean, one of the great benefits of being chief is you are most senior. So if you really like a case, you can assign the opinion to yourself, and then also like strategically, maybe you have colleagues who are in the majority with you, and some of them have very strong views, and some of them have kind of a little bit more in the middle views, and you may say, okay, the person in the middle views may write something that captures more of the court, so I'll assign it to him or her.
And I'll just add one little quick addendum on that too, which is that from a clerk's perspective, it's particularly great clerking for the Chief Justice for a ton of reasons, but this is one of them, which is that you're working on and getting to help out on some of the most interesting and fascinating cases. Every case that comes to the Supreme Court usually can be interesting, but some of them are a lot more interesting than others, and oftentimes you get a larger chunk of that diet when you clerk for the chief. So it's a particularly enjoyable experience.
All right. My name's Scalisi. I'm going to ask the next question. So it's a little long, I'm sorry, but speaking for myself personally, I just can't help but notice that very quickly after achieving a pro-life supermajority in the Supreme Court, there was the decision to overrule Roe v. Wade. However, I haven't seen any other rulings to help kids in foster care systems or most single mothers who are the majority of poverty. And so I was wondering if perhaps the justices on the Supreme Court have agendas to accomplish certain policy goals, and therefore they pick cases out of those 70 some odd cases a year to help achieve those said goals.
Sina, were you able to hear that?
Yeah, that's a great question. So one of the structural limits on the court, which impacts your answer, is they can only decide cases or controversies. And that means like when folks sue each other, whether it's like a person suing another person or the government suing someone. And so the cases that trickle up get there in that posture, which is to say you're not going to get you generally don't get like a case that says, hey, should we do something about poverty? Unless you might have like someone saying, hey, we should read Medicare, the law this way, and the government takes a contrary position. So that's the way in which it bubbles up. So that means there are certain kinds of cases that get to the Supreme Court a lot more right off the bat. So if you clerk there, one of the first things you realize is a lot of these cases coming up to you are criminal cases. And they're not just any kind of criminal case, they're post-conviction, they're in a habeas context, and that's when they're getting to federal court. So these folks went to like state court, they were like convicted, they exhausted all their state court remedies, now they're suing in federal court, and that's when it gets to you. So the Supreme Court's like what it can pick from is not a random sample of like issues that are important to the entire country. So that's to pick from that. So within that, there's just been this very concerted effort for decades to test the limits of what the abortion right means. And it's fascinating because like in the 80s, when President Reagan appointed justices, a lot of folks thought these are Catholic justices like Justice O'Connor, Justice Kennedy. Now there's a majority for like the pro-life view. And then it got up there and it didn't happen. And it just, but like still, I mean, it still has been this huge issue in the United States. And it's not only been a huge issue, it's been a huge issue that's been litigated, right? And so I think to understand the court's docket, you need to understand like, all right, which cases are people like really litigating? And so that's definitely been one. Sort of the gun rights have been another one. So and what gets litigated is a function of like on the ground, what do lawyers think is like part of like a good strategy? So right now you're looking at it, you're like, all right, I want to take a very expansive view of, for example, like the Equal Rights Clause of the 14th Amendment and what that means for education. It may be that organizations on the ground are like, hey, we don't think that's a good strategy for litigation. Let's pursue that with politics or other means, right? And so by the time it gets to the court, it's like all these people have made choices about what to litigate and what gets up there. And, you know, for decades, they've been wrong about like whether the court would overturn anything relating to the abortion issue. And then Dobbs came, and there's a reason it's been such big news is because it changed things that had been settled for a very, very long time. So I hope that answers the question.
All right.
I think actually I missed what you said. Does the court have an agenda? And I should address that. So in terms of like an agenda, I mean, I think the folks who get to the Supreme Court, they have been thinking long and hard about like what first principles are in the country. And in law schools and in post-law school debates, there are certain conversations that people like really enjoy having, and they don't map on perfectly to what the rest of the country's having. But by the time I think people are on the court, they have thought about these, and they may have views on some of these things. But that agenda is like it just does not match one-to-one with what's going on in like a political conversation, if that makes sense.
All right, my name is Jessie Warden. I'm also a cabinet member here at OTC. And since Roe v. Wade was overturned and the court docs were leaked before it was officially like released by the courts, do you think that will change the process and protocol of those who work very, very closely with the courts, like the clerks?
Michael, are you able to hear that question?
Yeah, that's a great question. All of you are having great questions. The leak was, really unprecedented and a real breach of sort of the confidentiality requirements for people who work at the Supreme Court. We don't yet know what happened. I'm hopeful that they'll find out. But it really was a kind of a gut shot when I saw that. My stomach turned, because one of the really unique parts about clerking at the Supreme Court is that it's a small place. It's really small. It's a beautiful building, and but it's not big. And there's a certain set number of employees that have worked there for a very long time. Everybody knows each other. You're passing each other constantly in the hallways. There's a basketball gym on top of the building. So when I was there, I played basketball with the cops who worked at the Supreme Court, and with janitors and other clerks. We all kind of came together. And with that, there's also, there's holiday parties there. There's a real sense of kind of community and connectedness, and also seriousness of purpose, even though people disagree with each other all the time. I'm a very disagreeable person, at least from a legal perspective. And I disagree with every single boss, and lawyer on something, on some issue or another. And that's kind of part of the nature of the job. And I think, there's a shared idea of we need to still do our work in good faith, even though we have disagreements and sometimes very strong and deeply held disagreements. And the leak was a real breach of that sort of culture. In terms of your question of whether things will change, I don't know. I think it'll actually be kind of hard because the clerks play a pretty big role in drafting and kind of being part of the process there. So I think it would be hard to keep clerks out of it, but I don't know. I mean, I've heard some people kind of brainstorm some things that they could potentially do differently, but I think this is part of a problem that it'll be hard to solve, basically, I think. Yeah, so I don't know if that answers your question, but that's my first crack. I don't know, Sina, if you want to add to it.
Hi, I'm Miranda Morgan Irish. I too am a cabinet member. My question is, do you believe that there should be some kind of code implemented on the Supreme Court to ensure that the political parties are diversely represented with the justices?
You're able to hear that, Sina?
Yeah. No, because I don't think that political parties should be represented on the court. Which is to say, we've had a long and, in my view, great tradition of appointees disappointing whoever appointed them. And I think that the judiciary should be independent. Now, there are obvious ways in which that doesn't feel like it's the case or it's not the case, in that it matters who appoints the justices, it matters who the president and who the Senate is. I mean, you really can't dispute that. But at the end of the day, like when you go to court, like at the most basic level, you just want someone to hear your perspective and the other person's perspective and say, on balance, I think so and so is right. And so that really shouldn't be a function of your politics. And it's like when the court makes decisions that challenge what I just said, is that it's like at its weakest, and it can only do so much of that. Sometimes it's forced to, because like there's a Second Amendment. The Second Amendment says something about guns, and people have different views about guns. So if it says anything about guns whatsoever, it's going to disappoint some people and make other people happy. But at the end of the day, it should not view itself, nor should it be structured as like a political enterprise, in my view.
Hi, my name is Alex Neely, and my question follows the same train of thought that Miranda's question did. In the past couple years, our policymakers and the public have become increasingly concerned with the partisanship of the court. That recent rulings have started to appear as though politics is starting to bleed into it, follow along partisan lines. Our president actually, upon taking office, signed off on the creation of a advisory council made up of legal experts and constitutional historians to discuss the possibility of Supreme Court reform, structurally, what would be in line with the Constitution, and what that could look like. No actual proposals have been chosen, but my question is, how do the Supreme Court justices, what is their attitude about this? How do they feel?
Yeah, I mean, a couple of things. One is that I do think that there is so two things I think are true here. One is that the court, just statistically speaking, has gotten a little more fractured for sure, particularly this past term. But lots of people's perceptions about how the court's kind of divided politically are just wrong as like an empirical matter. There's actually lots of cases where you have crossovers from different justices who are voting because their best reading of a case or of a statute, of a law leads them in that direction. And so just for one example, just recently there was that Title VII case about Title VII including folks who are transgender, and Justice Gorsuch, who was appointed by President Trump, and Chief Justice Roberts, both were joining with the quote unquote liberal justices. And it's because that's what their best reading of the statute was. I think a lot of times these cases that don't have the partisan divide don't always get as much attention. But I think that's important for people to remember, is that there's lots and lots of cases that the partisan kind of divide doesn't line up at all. It's not, now all of that's to not kind of deny your point, which is that there is what appears to be like, a more fractured Supreme Court along political lines. And, what can be done about that, or how should we think about that? I think one thing that underscores the difficulty of that question is this commission that you mentioned had a very difficult time with their mandate and kind of came up with an assortment of recommendations, but there's it was very hard to find agreement on recommendations. And then many of these recommendations for reform were potentially not constitutional. And so they would require constitutional amendment. One of the biggest reasons for that is that the justices have life tenure. And that's one of the biggest constitutional impediments to these reform initiatives. Because one of the ideas that sounds pretty palatable, I think, at least in some respects, is to have term limits, to have justices, on the court for 15 years, have it tied to a presidency. So you could have, for instance, this is one proposal, each 4-year term gets to appoint 2 justices with 15-year terms, and you have it all staggered out. So you could have a kind of more tightly tethered connection between the democratically elected president and the members of the Supreme Court. So on a blank slate, that sounds like a good idea, I think. I think it'd also be unconstitutional. So you'd have to have a constitutional amendment, which is a very difficult sort of process. So I think that's one of the biggest kind of constraints on some of these calls for court reform. So just to kind of summarize, I think that this issue sometimes is based a bit on a misperception, not to totally deny the issue, but there is a bit of a misperception. And I would just encourage you, a great resource is SCOTUS blog has these stat packs, which are just a ton of statistics from the end of each term. If you look at those, you'll see that things are a lot more complicated in terms of how justices are voting than maybe you will be led to believe by various news sources. And then in terms of court reform, I think it's a good idea, but it's got some constitutional difficulties that kind of keep it from going forward.
SCOTUS blog, a great recommendation. Thank you, sir. And Sina, based off that question we just had from Alex, a really good question. Can you just give us the sense, just to capitalize on what Alex said, can you give us the sense of how receptive you think Supreme Court justices might be to a number of reforms that have been floated over the years?
I think that the court, by its nature, is a very conservative place. I don't mean that conservative like politically. I mean that take cameras in the courtroom. Working at the Supreme Court, you realize you have this process that works very well in the sense that, unlike what you see in the newspapers and in Congress, where it's like a lot of people are sort of posturing for the media, you have extremely substantive conversations. So if you listen to oral arguments from the court, if you don't know the issues, you're probably bored because they're down into the details of like what the laws mean and how to think about them. And that's an amazing thing. And so it's not like there's something inherently wrong with the idea of a camera in the courtroom. It's just that changing the dynamic of this process that works so well, such that maybe now the lawyers there, in addition to the substance, are thinking about, hey, there's a camera over here. Maybe I can say something like great for the media. They just say, why are we going to take that risk? And I think that's the kind of mentality that is brought to like a lot of reforms. That's not to say that they wouldn't hear reforms they think are good ideas. I mean, I can't speak for them. Maybe they have different views on this issue. But I think relative to other places, because it's such a good thing going, the bar for suggesting something is a little bit higher because you just don't want to mess with a process that is very substantive.
Hello, I'm Austin Kennard, a cabinet on the Politically Active. I was wondering, how will the Bruin versus New York Rifle Association court case affect future gun laws across the country?
Were you guys able to hear that?
Yes. So I have to kind of, I was fresh on this case like a month ago or maybe 2 months ago, and I'm not quite as fresh on it now. My recollection is that it was a 2008, I think, Supreme Court decision called Heller decided that or held that the Second Amendment includes an individual right to bear arms to protect oneself inside the home. And this case, as I recall, and again, this is a little faint in my recollection at this point, but Bremerton extended this beyond the home and struck down this this statute from New York, which basically said that in addition to, for a citizen to get a carry permit, they had to show special cause, like special need for the permit. And the court said that that's inconsistent with the Second Amendment and Second Amendment's kind of protected rights. And then also that I think one of the innovations, or at least one of the important parts of this case, was the methodology for Second Amendment challenges that Bremerton. I'm saying Bremerton. I don't know why I'm saying that was the praying coach case, right? Wasn't Bremerton?
Yeah, this one's Bruin, right? You're asking about
Bruin. I'm
Bruin.
sorry, I'm saying Bremerton. That's the praying coach case. Bruin. So when I said Bremerton, I meant Bruin. But the other innovation or kind of important part of Bruin, I think, is that it adopted this historical methodology for determining whether a restriction is consistent with the Second Amendment. And so all that's to say that I think it will make it harder for different states, municipalities to have gun restrictions and carry restrictions. And I think that's like the main effect, is that it's going to be harder to limit different types of carrying restrictions. Sina, if you remember the case better than I do, you feel free to.
Yeah, I mean, look, my reaction is Bruin, in light of Heller, was a pretty blatantly unconstitutional law, in that Heller said you have a right to have a gun in your house, and then Bruin said you can't carry it out of your house without this permit, and then these people couldn't get a permit. And so it's like, if you're moving, let's say you're moving from one place in New York to another, and they're not giving you the permit. So it's a little narrow. Like when I say it's a little narrow to know how much it applies beyond that, because it's so, if you just take the premise, which a lot of people would disagree with, by the way, but let's just assume the premise you have a constitutional right to have a gun in your house. It's like, if you move, there's got to be some way to like move it to your next house, or if you're going to drive somewhere and go hunting or something like that. So I think being really aggressive on that carry is going to reach constitutional issues, but completely TBD about more reasonable kind of restrictions.
When a Supreme Court justice decides on a case, they're often advised to use the Constitution and to do their best to stick within the lines of the Constitution. But at times, Supreme Court justices have to use their intuition or their gut feeling. When are these times that a Supreme Court justice actually has to use their gut feeling and not just the Constitution when deciding a case?
Yeah, so I mean, I think the way I would put it is there are certain types of questions where judges are bound because there's very clear rules and laws, and once they have their best reading of the statute, they just follow it, regardless of whether they like that outcome or not. That's my understanding of how judging should be, and I think most judges understand their role more or less in that way. Then there's also kind of discretionary realms, and so one discretion. So you say gut feeling, but I think another way of referring to it is just as where discretion comes into play, where it's not math, but it's judgment. And one example of that is granting certiorari. So, there's these thousands of cases that are trying to get into the Supreme Court. That's a area where a Supreme Court justice, there isn't a rule to follow for them. There's kind of guidelines, but that's where they get to use their gut or their discretion or their judgment to make those kinds of decisions. And that's a completely appropriate and sort of, normal use of judgment. And Yeah, so I guess I would say that there's like a category of cases where I think it really is more kind of balls and strikes, where they're just trying to call what they think is like the right call. And then there's a category of cases where they get to use their judgment and discretion, such as in deciding certiorari. And there, judges do rely on other, principles that maybe are more sort of like history and tradition, things like that, things that are a little bit more squishy. And I think that is one of the places where we've had some conversations so far today about politics and judges having different politics or sort of different views. This is an area where that plays out, I think, and I think legitimately so, because this is where I think judges can legitimately bring into play some of their sort of intellectual priors in terms of how they exercise their discretion. I hope I answered your question. I don't know if I talked around it, but I was trying to hit it. Feel free to follow up if I didn't answer.
All right, I will ask the next question. So within the walls of the Supreme Court, like maybe at those Christmas parties you were talking about, or just in general, is the gender and racial disparity prevalent within the Supreme Court, particularly in the justices, ever discussed as something that needs to be changed or as an issue, or do most clerks and justices not really see it as a problem?
So let's see, for the justices, because the president has to appoint and the Senate has to confirm, it's like less of a internal conversation because there's nothing to be done at the justice level, like at the court. They could write their congressperson same as the next person, but they don't have any power on that. There's more of a conversation about clerks. And so you'll see like patterns among like, is it 50% women and who has 100% men in terms of clerks? And I think that's a real issue. I just had a conversation about it last week. It was definitely a conversation when I was there. And then there's everyone else who works at the court. And I think like the government, like the rest of the government, again, that's like definitely something that people like think about, have different philosophies about. I don't know if there are numbers, Mike, you may know, are there numbers on like
Yes.
clerk hiring? Okay, someone's compiled numbers on clerk hiring. Like I know, for example, I think Justice Kavanaugh hires at least 2 every year, sometimes 2 women every year, and sometimes 4, and then others seem to have no real pattern. But I don't know, we'd have to look that up.
So this is one of those ones that's kind of counterintuitive to some people. But yeah, I mean, Justice Kavanaugh has one of the most diverse records of clerk hiring, including from when he was on the DC circuit. He was the first justice ever to hire 4 women clerks. All of his clerks were women. And that was the first year, I believe, it was the year I clerked, that there were more women clerks than men clerks. There's still, and I think that disparity has really narrowed. It's still, it's still there some years, but it's narrowed. I think there is still a very substantial discrepancy along race lines. And even there, though, it's kind of counterintuitive to some folks, but like, for instance, Justice Ginsburg, who was on the Supreme Court for a long time, had a very poor track record in terms of racial diversity in her clerks. At least I know for a fact with having African-American clerks. I think she had maybe 1 in her entire tenure. And other justices, I think like Justice Thomas or some other justices who are conservative, have actually hired a more diverse. So I don't know for justices, different justices, what criteria they're thinking of and relying on or how they approach that. But I would just say that the results are actually not always what some people would expect them to be. It's actually a little bit more kind of complicated than that, I think. But just to see this point, it is something that's on the radar and that's thought about and talked about.
Yeah, and I should say Justice Ginsburg, on the other hand, was a force for having the broader public think about diversity on the bench itself. I think she famously said something along the lines of like, we'll be done once like the majority are women or something. And
I think she said all 9, didn't she? I think she said all 9.
Yeah, which was perfect because no one historically had blinked that there were 9 men.
Yeah.
And
Yeah.
so it was a great way of inverting it to say, all right, well, it's all 9 women. So she did very publicly, but because your question was more about like the holiday parties or something, it's less, I thought it was less of like an express conversation, because especially as a clerk, you're just sort of like respectfully kind of walking around. You're not having that conversation so much.
And just to be clear, I didn't mean my comment as a knock on Justice Ginsburg. It's just, so because I don't know what her hiring criteria was or anything like that. But that's just how things shook out over the years. It's that these numbers are all compiled in terms of the clerks and their breakdown kind of over race and ethnicity and gender and all that. And for whatever reason, it kind of shook out in a way that not everybody would expect.
All right, continuing off of the conversations about the clerks, do you think the clerks are biased, and do you think they have any influence at all over any decisions that any of the justices make?
I think that a couple of things that are kind of contradictory seeming. One is that I think most law clerks think that they are more important than they are, as just a general rule. I think most judges and justices are incredibly smart, serious, accomplished lawyers and legal thinkers and judges, and you're there to help them out, but they're making the decisions. With that said, I think that there are certain areas where clerks really do and can make an influence or make an impact. And one of those, I think in particular, is certiorari, which is that sort of initial funnel for cases getting into the Supreme Court. So clerks do because of the high volume of these, they're basically applications. It's called a petition for certiorari, but it's basically like an application to get in the door. And there's so many of those. And clerks will summarize those and write memos on them. And depending on that, I think clerks do and can have some influence there. I think most clerks that I know take their job seriously and are trying to kind of be faithful agents of their boss, or the justice that he or she's working for, and not trying to sort of put their thumb on the scale. But I don't think that that's an impossible thing to do. So yeah, I don't see if you have more thoughts.
Since the Supreme Court justices have life appointments, do you feel that it allows for the Supreme Court to make decisions that don't regard the public's view?
Yes.
Yeah, I think that's the point. Yeah, I don't think that they're tasked with thinking about the public's view in the sense of like what's favorable. I think they're tasked with figuring out what the law is. Obviously, the more judgment that's required, the more people can disagree, and that can be an issue. But they're not supposed to be thinking about what's popular.
Just one thought on that is like there's a dialogue that's supposed to happen and does happen sometimes when Congress is functioning between Congress and the Supreme Court. So there's a whole bunch of cases where the Supreme Court will issue some ruling, people really don't like it, and then Congress will pass a new law. Just basically, and they call it a statutory override. And it overrides the Supreme Court's decision and says, well, that we had this one statute and people were trying to apply it in this one way. And the Supreme Court said no, because the statute didn't really say that. And then Congress will come back and say, fine, now we'll say it clearly. And that's exactly how it's supposed to work, because the Supreme Court isn't supposed to be trying to get the pulse of what people think. Congress is supposed to be doing that. And then when they do that, and they do that kind of statutory override, that's that sort of dialogue, push and pull that's supposed to happen in the system of checks and balances.
Throughout the history of the Supreme Court, they have consistently upheld the right of the federal, state, and local governments to use eminent domain to take private property on behalf of corporations for the economic benefit of wherever this is happening at. Just to name a few cases, there is Penn Central versus New York in 1978, the Hawaii Housing Authority versus Midkiff in 1967, Kalo versus the City of New London in 2005. I wanted to ask if there was any specific thought that the Supreme Court had on what kind of economic development needed to be occurring, if this is a utility specifically needed by the town, or if just the a corporation bringing jobs to a town was sufficient to use eminent domain.
That's a truly awesome question. I love it. I think of the cases you mentioned, only the last one, which is Kilo, permitted the government to take property for a corporation. I think that's as far as that's been pressed under the pretty aggressive reasoning that the corporation create jobs, as their benefits, blah, blah, blah. Historically, the purpose of this has been like, there's a railroad. We don't want like each plot of land along where the railroad's going to go to be the holdout and to have all this leverage against the railroad. So we're going to build up our, the country by permitting the railroad and making sure private property is honored and people are justly compensated. And then the question is, what's analogous to something along those lines? There is not a great like concrete answer. I mean, you could build an academic career or a legal career kind of testing that question and figuring out where it goes. Now, as a practical matter, there's something a little bit like strange about this in the sense that like, if you're going to do this in like a wealthy area, all these people are going to sue you. And so there are like your legal logic better be very good if you're going to pursue this. And so the areas where this question is like more likely to come up, unfortunately, is like where people have like less resources to litigate. So I think that's where the action would be. The question is like, all right, why is the government taking that property? What is it using for? And I think even just empirically answering that, I don't know the answer to it, but even empirically answering, where is eminent domain being used? Does it have some sort of disparate impact? When does it create litigation? How far does that litigation go? Those are all really interesting questions because, as you pointed out, not a ton of Supreme Court cases on it because not very many of these cases make it that far. And more generally, takings is this like interesting area where the cost of litigating is not usually like all that worth it. And so sometimes you get people who, for principled reasons, push it, but you don't have a ton of case law to help answer your question. So very long way of saying I don't know the answer to your question, but it's a very good one.
We are going to open it up. Our cabinet members have started off the conversation. For a little while, we wanted to open it up to anybody else that might be on the floor. We have Josh in one corner. So anybody who wants to raise their hand, anybody have a question for any of our Supreme Court former clerks among us? Anybody, feel free to raise your hand. All right, so I'm not like the president or anything, but I just wondered what made you want to be a clerk and what's the process in order to become one?
That's a great question. I hadn't heard too much about clerking before I went to law school. But when I was in law school and I was talking with more lawyers, lots of them talked about it as being one of the like best young professional experiences they had as a lawyer. For a couple of reasons. One is that you get to work very closely with this kind of senior, very well-established person in the legal field in this kind of close, intimate setting where with lots of clerkships, there's 3 or 4 clerks and a judge. And so, and then also, so that's kind of one element to it, kind of the mentorship. And then another element is you get to see a really interesting array of cases. You get to see it from the other side of the bench, from the decision-making side of the bench, as opposed to the kind of advocate side of the bench. And so I ended up clerking for 3 years, 3 years for 3 different judges. And I absolutely loved each one of those years. And in terms of the process, you apply, it's a sort of an application packet with your grades and letters of recommendation from law professors. I don't think you write a personal statement or anything. I think it's like a 1-sentence cover letter, and then you usually will have an interview with the judge or justice beforehand. So it's pretty, I think in some senses it's a straightforward process. In other senses, because there's so few clerkship positions for each judge or justice, it can feel like a bit of a crapshoot.
Okay, my name's Aspen. I am a member of Politically Active, and I was just wondering what your guys' favorite cases were.
Yeah, I mean, at least for me, I really like cases that were not that interesting to the public, and there are cases that were about the court's jurisdiction, which is like whether or not the court is allowed to hear a case in the first place. Just because I thought the legal logic in those cases was like the most interesting to kind of like think through. By extension, my least favorite cases were like the ones the public was most interested in because it would just had the least legal logic. I don't know, Mike, if you have a different perspective.
I don't know. Yeah, I end up getting interested in like every legal case that I work on. Like, just I don't know why, but some more than others. And when I was up at the court, at least I remember being interested in enjoying some of the cases where the Chief Justice would write dissents, because it's a chance to write and to kind of see a different style from the chief, which is very interesting. So when you're in the dissent, you get to kind of take shots, which is fun.
Can I piggyback off that answer, particularly for Sina? Because I used to work, before I got this job, I used to work at 911, and 911, obviously that's the worst calls that could come in, the worst emergencies that could happen. But if you're ever in the room, the operating room, the 911 dispatch room, it's like working at Dunder Mifflin. It's just the energy is really low. Everybody's really calm. Obviously, Supreme Court cases deal with the hottest topics, and there was a roiling national conversation about what you guys are doing. Does it feel like it? Do you feel it when you're in the room, or is there a more serenity where you happen to be?
For me, there was not 1 second of my clerkship where I didn't feel the gravity of the job. I mean, just the architecture of the building itself, which is like emphasized through marble, to the meetings you have with literally who you're having meetings with, the importance of what you were doing was always present. But it rarely, if ever, felt like it was heated or antagonistic the way that I get the sense like when I read about politics in the news that gets. And I think what's going on beneath that is that while most people are thinking, all right, how do the politics shake out? Who's on what side, blah, blah, blah. You have just a bunch of people who are trying to do their jobs. And part of doing your job in any environment is not letting other people down. And the other people include people who you disagree with. And so you want your reasoning at a minimum. What you want to hear is, I disagree with you, but I totally understand what you're saying. You don't want to hear, oh, that's disingenuous, that's a silly argument. So you're very focused on that, and you're a little bit self-conscious about, are any of my arguments not right? And so the people who disagree with you are actually incredible allies in making sure that you're not thinking through something incorrectly, because they're going to be the ones who point it out. And so there's this, because of that, instead of antagonism, I felt during my year incredible amounts of collaboration, even on the cases that are the most hotly debated in the public.
All right, more questions. Anybody else in the room? Please show your hand, and could you run this out to?
Thank you. What's family life like being a clerk?
We able to hear that question, Michael?
Yeah, I think it's different for different justices in terms of how maybe demanding the clerkship experience is. I think for the Chief Justice, he has very high standards, but he's also incredibly talented and able to do the work by himself without us. And so he's also very humane and a real gentleman. So I think, we all worked for him hard, but I had a son who was, I guess, 2, when I was clerking for the chief, and I think I was able to still be a father and to kind of help take care of my son. And I tried to really, give everything I had to the clerkship, but I think it was one of those situations where it was possible to do both and to do both well. I don't know what your experience was like, Sina.
Yeah, I mean, it's definitionally a 1-year job. So I think at least some of it would be really hard to do for years on end. So it's a little bit easier given that it's a 1-year job. I didn't have a family at the time I was at the court, so it didn't really affect me. But there are a lot of folks who do have families, some of them very big families, and so I got the sense that everyone kind of figured out what balance worked for them. And definitely just directionally, I think the world, or at least in the US, things are moving in a better direction for that question. So it's becoming like something people think about more. It's something that's easier to bring up with your colleagues. One of the best things, like I said, it's a very like collaborative environment, all things said. So if something happens, you need to run home. You have 3 co-clerks who will happily, no questions asked, do anything for you. So it's a good setup, I think. I mean, it doesn't mean it can't improve. It doesn't mean it's not hard at times. It certainly doesn't mean that it's a sustainable, like 25-year thing, or at least for some of the justices. But I thought it was workable. But that comes with the caveat that I didn't have to really balance the way other folks did. So my perspective is probably less important.
Anybody else questions for people that worked hand in hand?
Yeah, sorry. So my question is kind of, can you tell us what the research looks like on the big hot topic cases, especially like Roe v. Wade recently? Like gathering the research, if that made any sense.
So I don't know, Mike, how you would answer that. I would say I cannot. I mean, first of all, this is all after my term, so I haven't really followed that in particular. But I will say, I think it brings up this important question, which is like, how do people know anything about anything at the court? And thankfully, as a clerk, it's not your job to gather research, and it's probably not even like, it's probably your job affirmatively to not be gathering research. What you do get is briefs from the parties, and then there are these other parties called amici, or everyone pronounces that a little bit differently, but I call them amici, and they're quote unquote friends of the court. And so anyone can come in as a friend of the court and offer a brief that says, here's some perspective that's missing. So for example, if there's like an abortion case, you will see a lot of parties weigh in. You'll see pro-life parties, pro-choice parties, doctors who are neither pro-life nor pro-choice, just want to tell you how doctors think about this. You'll have like organizations of OBGYNs, you just have everyone. And among all these briefs, you have if there's anything left for you to learn, it would be amazing where you'd have to go to find it, because especially for these really important cases, there's just such an incentive to put this stuff in front of the court. So some of these cases, especially the hot button cases, had like many dozens of briefs that we would have to go through, and that would kind of lay it all out there.
More questions for our visiting clerks here? Any more questions?
So one of my questions for any of the clerks, if you could ever talk about it, what was during your term one of the most hot topics that you ever went into? If you could.
I think a sort of so a lot of times with the Supreme Court terms, it at least appears that you'll have certain terms that have a lot of kind of high profile cases, like cases that get a lot of play in the media. And just by the way, those cases are not always the cases that will have the most impact on the country and the legal system. But they usually touch some kind of cultural touch point or something like that, so they get a lot of coverage. But you'll have cases that are very technical, cases on immigration law, on criminal law, that do not get a lot of play, that actually have huge impact. Anyways, different terms, it does kind of seem to cycle a little bit, where you'll have almost every other term where there's kind of more high profile cases. My term was, I think, considered to be a term that didn't have as many high profile cases. But I thought we had a lot of really interesting cases, and one that I think people thought was sort of interesting was this census case, which was about in the Trump administration and their approach to the census and how and when they were counting people and when they plan to stop it. And that was a kind of an interesting sort of controversial case from my term.
Yeah, for my term, let's see, it was Defense of Marriage Act and the quote unquote Defense of Marriage Act, Proposition 8, and then the constitutionality of the Voting Rights Act, which is Shelby County. I think those three probably garnered the most public press, and I think for very good reason.
I mean, that's a high profile term.
To bring this to a close, gentlemen, what is the top of your list thing that you wish us laymen who don't work in the building like you guys did had a better understanding of?
I would say two things because I talk too much, but I'll say them quickly. One is just specific to the Chief Justice. I was worried I was going to disagree with him on everything, and because he and I don't, my politics and my views on the law aren't always aligned with his. And when I got there, I found that we disagreed much less frequently than I thought we would, and also that he was just an incredible Chief Justice, hardworking, smart, decent, kind, and I don't know. I kind of feel like both sort of political sides find fault with him on various things. I think that's probably a good sign, actually, for a judge. And I feel like he's an incredible Chief Justice, and that we're very lucky as a country to have him. So that's one thing. The other thing is that I think the federal judiciary in general is one of the best functioning branches, or it's the best functioning branch of government. I think it's full of like really good civic minded public servants who work really hard, and they're really competent and smart and good at their jobs. And it's not to say that there aren't lots of problems and ways for improvement, and there certainly are. But I think when you put it side to side with Congress, for instance, it's I think kind of one of the kind of federal crown jewels that we have in terms of governance. So I don't think I would have said that before my clerkship experiences, but afterwards I definitely think that way.
And Sina, can you bring us to a close once again? What do you wish, top of your list, what do us laymen not understand about the Supreme Court that you wish we understood better?
Well, I'd actually say don't underestimate its accessibility. So the opinions, some of them are technical, but they're generally readable. And so for the cases you care about that shock you or don't shock you or hit the press, the opinion's available online. Go read it, print it out, read it, and like get into the weeds such that there's no longer this divide between sort of like lawyer and quote unquote layman, because in a rule of law, I don't think there should be any real division between lawyers and laymen. Like you have every right to understand what the court's doing, and you should exercise that right by looking at its main output, which is not like media or journal articles. It's literally the opinions. And if the opinions don't make sense, and if you read them a couple times, they don't make sense, maybe there's something that you should be criticizing. And the court should not be immune to that kind of and that's what like law professors do in law journals all the time. And that's a conversation you should feel completely free and encouraged to participate in, notwithstanding any sort of like law or layman divide. The other thing I would encourage you to do is understand like the amazing empathy that comes from when you have to argue the other side. And one of the like cool things of being a lawyer is like you do have to understand what the other side is going to say, because if you don't, they're going to come at you and you're not going to have anticipated their arguments, and you're going to look weaker than you did. So for any case, especially the ones where you really disagree with the court, try to be the lawyer for the side you disagree with, because what you'll find is you're not going to change your like North Star or your principles or anything like that, but you will understand where folks are coming from better, and you will find that you are more persuasive as a result. And one of the benefits of clerking at the court is like you literally have to do that for your job. And so I got the benefit of a 1-year job description where I had to build this skill. But everyone can do it. You don't have to clerk at the court to do it. You can just start thinking, okay, I'm going to take the other side's position. Like, what would they say? What are their best arguments? I think that's it.
Sina, Kian, Michael, Clemente, round of applause. You guys are so generous with your time.
This was really fun. Thank you for having us.
Yeah, honestly, this was very pleasant and engaging, and you asked really interesting, thoughtful questions, and I'm going to keep on chewing on some of these. So thank you so much for having us.
And thank you, you guys. All right. Thank you so much, guys. That was our Constitution Day event. I hope you picked up a lot. And in the meantime, you want to get more involved in some of this politically active stuff, join our Remind by signing a sheet on your way out. Thank you, guys. And thank you, you guys.
Okay.